Welcome to the monthly Consumer Issues program hosted by Cornell Cooperative Extension of Tompkins County. On the second Thursday of each month, we're joined by New York State Assistant Attorney General Michael Danaher, who makes a presentation on a topic of consumer interest. Today's program is on tenant landlord rights and responsibilities. After his presentation, Mr. Danaher will answer questions that viewers have submitted to CCE Tompkins in the Zoom chat box. This presentation also will be available on the CCE Tompkins YouTube channel and will be broadcast next month on Mondays on Public Access Channel 15. Thank you for joining us today, and now here is New York State Assistant Attorney General Michael Danaher with today's program.
Hello, Sandy. Hello, everyone out there, and welcome to our monthly Consumer Issues program. This is one of the big topics that we talk about here at our Consumer Issues programs, doing it twice a year, usually in the fall and in the spring. And we are at an especially hectic time when it comes to landlord and tenant issues, principally because of what has been going on during the time of COVID. And so because of the limited time that we have, my focus today is going to be on what the current status of the tenants and landlord rights is in this time of COVID. There's been new laws enacted and new laws thrown out, and then other new laws coming in and them being thrown out. And now we currently have a new one that just went into effect last week. So this is what is going to govern us until January 15 of 2022. So when we revisit the issue next spring, maybe this will all be changed. But I wanted to bring everyone up to date on what the current status is. And I can't do that without giving some historical perspective. And when I say historical, over the last year or two, not over the last 10 years, just to do a little bit of background and on issues we talked about last spring, some of which dealing with the COVID restrictions that went into effect. That starting in the summer of 2019, there was a whole host of changes that were made to general landlord and tenant rights and responsibilities. We've gone over those somewhat. They've been changed modestly over a period of time, but now more recently, there's been this huge change. So I want to kind of talk about that to give everybody an idea where everybody sits. And this is whether you're a landlord or you're a tenant. And hopefully you can disregard my phone going off. I don't know how to silence my actual phone. I have my two cell phones silenced, but now my office phone still rings. But we'll just ignore those as they come in. So let's talk a little bit about history of the COVID pandemic, at least as it relates to evictions and to landlord-tenants' rights and responsibilities. So although it seems like, depending on your perspective, real long time ago or a real short time ago, starting back in March 7th to be exact, of 2020, that's when the whole COVID restrictions and everything started to take place. And you may recall that the governor at the time, Governor Cuomo, issued executive orders dealing with evictions and forcing people out of their homes. So the initial eviction executive orders were issued on March 7th, and that called for the governor called for the halt on starting all evictions and executing any evictions that I believe was originally set to go through May of that year. And then there was extensions of that. Finally, the state legislature, and the law was thereafter signed by the governor, governor issued executive orders, but the legislature, signed on by the governor, issued actual laws in the state of New York. And those laws went into effect at the end of December 28th of 2020. It was the Emergency Eviction and Foreclosure Prevention Act, and it was affectionately referred to as EFIPA. EEFPA, an acronym. So originally it was just an outright halt on evictions. Then this law went into effect, and the law was that a tenant could sign what was referred to as a hardship declaration. And by signing that hardship declaration, that stayed any pending eviction matters or stopped the actual evictions themselves. So the grounds for that hardship affidavit declaration was that the tenant had lost significant income due to the COVID emergency, or had an increase in his or her necessary expenses, or they had child or elder care responsibilities that would prevent them from moving, or other COVID circumstances that restricted their ability to pay rent or to move. And also that moving would provide a significant health risk to those, to the tenants who would be moving. Now, it did not apply, in other words, the hardship would not apply to stay in eviction to tenants who were causing damage or infringing on the rights of other tenants. Now, that law was set to expire 2 weeks ago, on August 31st, 2021. However, the Supreme Court of the United States stepped in on August 12th, so a month or so ago, and found that there was a pending proceeding that was going on through the federal courts. And in the federal lower courts, the trial court and the Circuit Court of Appeals had rejected it was a landlords association, or landlords, had denied any preliminary injunction, meaning that the landlords or landlord tenant association had asked for the court to issue an injunction preventing the delay or stay of evictions pending the outcome of the case. And the two lower courts rejected that request for a preliminary injunction that would be in effect through the time that the case was being heard. Well, it was emergency applied to the Supreme Court, and the Supreme actually they had issued a preliminary injunction that would not stay these proceedings. So it went up to the Supreme Court of the United States, and the Supreme Court held that it was going to enjoin enforcement of the eviction hold due to a determination by the Supreme Court on a preliminary review. It wasn't a full review, preliminary review. They found that filing the hardship declaration was the use of the hardship declaration to stay these proceedings was not valid because it did not give the landlords an opportunity to challenge the hardship declaration. So just by the tenant submitting a hardship declaration, whether it was true or not true, the law in New York did not give a landlord the opportunity to challenge that. The court held that there would be an injunction from the enforcement of that stay of having evictions. So that threw, in essence, the eviction hold out. Now, on top of all of this, again, more historical context, the federal government had issued through the CDC, the Centers for Disease Control, had also issued their own eviction moratorium that prohibited landlords from starting non-payment evictions until initially December 31 of 2020, and it was thereafter extended. And that one was struck down in May by courts. And the federal government, under the new administration at the time, President Biden's administration, CDC, issued a second set of eviction moratoriums. And that was ruled on by the Supreme Court at the end of last month, August 26th, saying that the CDC did not have the power to issue these eviction moratoriums, that was something that the federal legislation, the Senate the Senate and Congress needed to enact themselves. It couldn't be done by a government agency, and that got thrown out. So as of August 26th, there was no federal law, and that although New York's law was still in effect going to the end of August, the Supreme Court had issued an injunction saying that hardship declaration was not valid to allow the stay of evictions. So what ended up happening? Well, last week, the legislature adopted and the governor signed, Governor Hochul signed into law on September 2nd, a new law, because the previous one had expired. Regardless of the Supreme Court's injunction on it, it expired anyway by its own terms on August 31st. So 2 days later, on September 2nd, the governor signed a new law that is now in effect in New York. That law has many changes to what the prior law was, including putting in the opportunity for landlords to challenge the hardship declarations that a tenant may submit, thereby addressing the issue that the Supreme Court addressed in issuing their injunctions. So this new law that went into effect on September 2nd, first of all, covers residential tenants and small commercial tenants, so small businesses. I'm not going to spend a lot of time on the commercial businesses. They run pretty parallel to the residential evictions, so we'll talk about that at the end. But it's designed to remedy the issues that were raised with the prior law by allowing the landlord to challenge the hardship declaration. And it was also designed to allow time for the rollout of the rental assistance program that was funded by the federal government, which is referred to as the Emergency Rental Assistance Program. And I'll call it ERAP to make it easier. ERAP, Emergency Rental Assistance Program. So although the money was funded, it has been in New York and in other states slowly started to roll out. It's picked up speed. So hopefully rental assistance is now getting out to people. This law that was enacted on September 2nd goes till January 15th of 2022. Who knows what will happen after that? Hopefully we'll be in a more health-friendly environment, and that the Delta variant will have subsided or substantially subsided. More people have gotten immunity through building up immunity or through receiving their COVID shots, which our office is encouraging people to get. The more people that are given immunity from this horrible and dreaded disease, the more likelihood that it will be able to be extinguished or significantly be reduced, especially since we're moving more toward the winter time when we're going to be closed up again. And although we've had a recent spike in the Delta variant, we're hoping that that won't last particularly long and that there will be enough immunity out there to help quash this. But In the meantime, we have this law that is still in effect. It's being challenged through the courts now. No changes have been made to date. So what's the coverage? It covers both evictions for non-payment and evictions for holdovers. In other words, tenants whose leases have expired and they're continuing to reside in the property. First of all, a landlord may not commence an eviction proceeding against a tenant where the tenant has applied for ERAP benefits. So the Emergency Rental Assistance Program benefits, if they've applied for it, which I haven't extensively reviewed what the program is, but generally speaking, it covers back rent for up to 15 months, as I understand it, and that payments would be made directly to the landlords to cover that. So if someone has filed for ERAP benefits, hasn't received a determination yet, or the payment has been made yet, there's a hold on being able to commence an eviction against them. If an eviction proceeding has already been started against a tenant and they have subsequently filed or previously filed for ERAP benefits and no determination has been made whether or not qualification has gone through, the eviction proceeding must be stayed until a determination is made. And so until a determination of ineligibility has been made, then the eviction proceeding would be on hold. A landlord's acceptance of these benefits, which hopefully they would accept, giving them payment for the back rent, there are certain guarantees or agreements that the landlord makes by accepting these benefits. One is, by accepting the benefits, all arrears have been paid, so that the landlord cannot proceed with a non-payment eviction proceeding because they've received the benefits. The landlord will also waive late payment and interest penalties that would be due on those back rent payments. The landlord also agrees that he or she will not increase the rent for 12 months from the time of receiving those benefits. So it would be an additional 12 months. The rent will not be increased, and that the landlord will not evict a tenant for an expired lease for a period of 12 months, except in a building where the landlord and or his or her immediate family resides as their principal residence. So if the landlord resides in the principal, or intends to reside in the principal in this building, and a lease expires, then the landlord wouldn't have to necessarily extend the lease. And the landlord must, if receiving these ERAP benefits, the landlord must notify their tenants of their rights under this particular law. So what does this law do? It expressly allows for evictions of tenants who intentionally, here's the definition, tenants who intentionally cause significant damage to the property. There's no eviction hold for them. Or the tenant persistently and unreasonably engages in behavior that substantially infringes on the use and the enjoyment of the property by other tenants. Or 3, causes a substantial safety hazard to others. So that's your objectionable tenant. So the new law allows the landlord to proceed with eviction when he or she can prove any one of those circumstances. Again, proving that the tenant intentionally caused significant damage. So there's a whole big thing to grab a hold of there. Intentionally causes significant damages. So courts are going to have to interpret what intentionally causes significant damages. Or persistently and unreasonably engages in behavior that substantially infringes on the use and enjoyment of other tenants. So again, that seems to be a pretty high standard of persistently, meaning isn't stopping at all, unreasonably, not in any reasonable way, engages in certain behavior that substantially, not infringes, substantially infringes on the use or enjoyment of the property by other tenants, or causes a substantial safety hazard to others. So again, substantial is the operative word there, I suppose. If the landlord intends to evict someone that falls within one of those categories, so that gets past the hardship declaration and gets past any type of eviction moratorium, the landlord must file an affidavit with his or her papers under penalty of perjury showing that one of these three things has happened, with a specific description. The statute requires a specific description of the behavior, the intentionally causing significant damage, or substantially and unreasonably engages in behavior, or causes a substantial safety hazard. The landlord has to detail in that affidavit what it is that's being done. Can't just make an allegation, we're causing significant damage. Well, what damage? How are they doing it? How do you know that it's intentional? Those sorts of things need to be established. So mere allegation of behavior is insufficient evidence. The landlord must prove everything. If let's say you have a situation, that's to start an eviction proceeding, you must have that affidavit. Let's assume that an eviction proceeding has already been started. If the landlord did not include this affidavit showing one of these three elements, they must start the eviction over, including reserving all the papers. So it's a redo. They have to start the eviction proceeding over. If the court previously awarded an eviction, the court must hold a hearing, even though there's a warrant signed by the judge giving the property back to the landlord. The court must hold a hearing to show and the landlord must show the tenant is still engaging in that persistent and unreasonable behavior or substantial safety hazards. Must show that the tenant is still engaged in that. Otherwise, the petition must be dismissed or stayed pending the outcome. So it is a pretty high standard. Also, when the eviction proceeding should go to court, the court is required to make the ERAP, the emergency rental assistance information available to the tenant so that they could apply for those particular benefits. So if the landlord intends to go through with an eviction on someone, this is something that would be in the normal non-COVID times. There are certain notice requirements that must be given to the tenant. There must be a demand made for, this is a non-payment, demand made for the payment, and then the tenant has to be given time to respond to that, make the payment. If the tenant does not respond, then the eviction proceeding can be started by serving and filing papers. Every written demand, whether it's the initial demand for the rent or the eviction papers that are being served to start the proceeding, every written demand must include with it the hardship declaration form. There is a form available that landlords can print out that is a hardship declaration form. So if you're going to send a notice saying that the rent is due for a particular period, you got to make sure you attach to it a hardship declaration that the tenant could fill out and send back to the landlord. That hardship declaration is available on the New York court website. I simply, rather than give you a long string of where it actually is, my suggestion to you is, I did it this morning. You just go onto Google and just put in New York State hardship declaration form, and immediately comes up, and you can click on it, and the form comes up in PDF version, and you can print it off. So that must be included with every demand. Every demand must also include landlord contact information. The contact information is name, address, telephone number, and email address, so that a tenant has a way to return the hardship declaration form. It also must include a list of not-for-profit legal service providers serving that county. Now, in Tompkins County, it's Legal Assistance of Western New York, or Law New York, is the legal service provider in the area. What the landlord could do is they could go onto the New York court website and look up not-for-profit legal service providers, and there should be a list of all the counties and who the providers are in those counties. And again, Tompkins County, it's Law New York, and the landlord would have to put a separate page that lists Law New York as a legal service provider. The papers must include the papers that the landlord is going to file with the court. It must include an affidavit from the landlord. One, you need an affidavit of service that the papers were properly served on the tenant. The affidavit from the landlord must specifically state that he or she has not received a hardship declaration. If the landlord has in fact received a hardship declaration, it must include on the affidavit that one of those circumstances of why the hardship declaration should not be sustained, including that the tenant is causing damage or is engaging in bad behavior that we talked about before. If the hardship declaration, the landlord believes that it is not a valid hardship declaration, for instance, the tenant has income that or assets that would be sufficient to pay the rent and just has chosen not to do that, the landlord must include in that affidavit that he or she has a good faith belief that the hardship does not in fact exist. The landlord must also include with papers that are being served on the tenant for the eviction. If the situation is such that the landlord has received a hardship declaration and does not believe, has reasonable belief that it is not a valid hardship, he or she must include a notice page on the front of the papers that are served on the tenant that's pretty much that says that gives notice to the tenant that if the landlord is challenging the hardship declaration, that the tenant there would be a hearing on that particular issue, and it unlike a regular eviction, which would exist in non-COVID times, the papers must be personally served on the tenant or occupant of the premises. It is only if the landlord, again, it has to be someone who serves court papers has to be over 18 and a non-party. So you'd have to get a process server or somebody that you know that's over 18 who's not a party to the case to serve it. That person must personally serve it to the occupant, unless with due diligence, meaning there's going to have to be several attempts to try to get the person personally. It's only after due diligence that they can't serve the tenant, him or herself, that one of the other avenues of service can be made. And one of the other avenues might be someone of suitable age and discretion at the residence that is then followed within a day of mailing a copy to the address. And I'm not going to get into all the weeds of that, but typically you could serve someone of suitable age and discretion at the residence if you followed up with a mailing. You can't do that under this law until after you have extinguished your due diligence in trying to personally serve the tenant. So then let's assume that you go through all of that and that the tenant, I'm saying the landlord goes through all this, and the tenant has defaulted, meaning the tenant did not appear, did not serve any response. In the typical situation, when non-COVID, you would be able to get a judgment, a default judgment. Well, now with COVID out there, the court is not allowed to issue a default judgment where a tenant has not appeared unless the court holds a hearing and the landlord still is able to prove all the procedural steps have been met, that notices were served, that the notices contained hardship declaration, demands were served with hardship declaration attached, that nothing's been received, that the papers in the eviction were personally served with proper notice, that there has been no, in one instance, there has been no hardship declaration received, or if a hardship declaration was received, that the hardship declaration is invalid for any particular reason. All that has to be proven at a hearing before the court can issue the default. In fact, if the court had previously issued a default judgment in an eviction, the default can be vacated, meaning removed, simply by the tenant coming in or either orally or in writing, asking the court to vacate the default. And immediately under the statute, it must be vacated and have to go through the whole process of the eviction. If the court had already gone through the eviction, had already issued the warrant, signed the eviction warrant, allowing the property to be returned back to the landlord, that's on hold. So the law enforcement, sheriff's office can't go out and execute on it unless the tenant has not filed a hardship declaration after receiving notice, or that a hardship declaration has been deemed invalid by the court. So if there is a hardship declaration, there is a rebuttable presumption, meaning it's presumed that the tenant has a hardship. That presumption can be rebutted with adequate evidence by the landlord, but as an initial instance, it's presumed to be valid on its face. So what in essence this does is it shifts the burden to the landlord to prove it's invalid rather than the tenant proving that it is valid. So it's a rebuttable presumption, so the landlord must prove otherwise. The hardship considerations that the court will take into in determining whether or not there is a hardship, and this is for a financial hardship, is one, the tenant's income prior to COVID. So what type of income did the tenant have beforehand and was paying the rent? Two, what was the tenant's income during COVID? What effect did COVID have on that tenant's income? Three, what liquid assets does the tenant have? What other assets, bank accounts, savings, anything else that the tenant may have in order to satisfy the rent obligation? And four, whether the tenant is eligible and is in receipt of financial assistance. It could be ERAP benefits, it could be social services benefits, it could be any other assistance, financial assistance that might be available out there. The court considers all of that to make a determination whether the tenant should have been paying their rent or not. Also, the court will have to take into consideration what type of expenses that the tenant has incurred. Maybe there's additional expenses that the tenant has incurred. The court also has to consider non-financial types of hardship. What would happen if the tenant had to move? Is the tenant caring for elderly or young persons who may be immunocompromised, or something that would make it quite a hardship to have to move? Is there another place to move to? Would the tenant have to move into a congregate setting, which might increase the possibility that they could contract COVID? So all of these things have to be determined by the court as to whether there is a valid hardship. And again, there's presumption that any hardship that is claimed is valid, and that then the landlord has to prove otherwise. These are the types of things that have to go through in order for an eviction to occur prior to January 15th. Unless extended, it will expire on January 15th, and we will go back to our old rules. And I'm not going to spend the time, I've talked a long time already, I'm not going to spend the time going through that. I've previously done this for Cornell Cooperative Extension, and we will talk about those again coming up when we get through this particular period of time. Just some other incidentals associated with this. One is this current law also applies to foreclosures of property. So if someone is unable to pay their mortgage payment, this hardship declaration can also be used to stall any eviction proceeding, to stall the foreclosure proceeding, which would result in an eviction of the landlord or eviction of the homeowner. It could be a landlord, and I'll talk about that in a second. But it can put the foreclosures on hold. The rules are generally the same, maybe some slight variations with foreclosures, but again, it's the filing of the hardship declaration with the court in the foreclosure matter, or with the mortgagee in the matter. So it's treated pretty similar. One of the hardships here, unlike with the eviction hardships, an add-on, is that one or more of the owner's tenants have defaulted on a significant amount of rent. So if the owner that's being foreclosed upon is a landlord, and is a landlord of who owns 10 or fewer dwelling units. They don't have to be in one building. It can be 10 or fewer in other buildings. But it's not it does not protect the large landlords. It protects the smaller landlords owning 10 or more fewer dwellings. If one of those dwellings, one of the 10 or up to 10, includes the primary resident of the person requesting relief or their immediate family. So it's got to be that the landlord or their immediate family is residing in one of the units. They are on this eviction hold. Understand that either with a tenant situation or a foreclosure situation, this process we talked about only stays the eviction. It does not stay the obligation to pay the rent or to pay the mortgage. So mortgage and rent payments are still accumulating, and they are still owed. It doesn't absolve the tenant or the landowner of the responsibility to actually pay a lease, pay the rental, or pay the mortgage. And when it ultimately expires, presumably on January 15th, those monies that are due and owing are due and owing, and could be subject to a subsequent eviction or a subsequent foreclosure, just so that everyone understands that. It doesn't remove the obligation to pay the rent. The other thing that this new legislation applies to is commercial leases, but again, for smaller commercial owners. Again, the procedures are relatively the same with the hardship declaration, and that there's been a significant impact on the ability to pay rent due to COVID circumstances. It only, again, applies to small business tenants. So who qualify? The person, tenant, has to be a resident of New York, according to the statute. Must have a business that's independently owned and operated. In other words, it's not part of it's their own business. It's not owned by a major, larger commercial owner or operated by a larger commercial owner. The example I'm thinking of is it might be a landlord of a plaza that may rent to large commercial enterprises. So they have to independently own and operate the business. The business is not dominant in their field, whatever that means. Again, it's intended to be a smaller business, not one that's a dominant type of business in the field, and employs 100 or fewer persons. So that's the person who qualifies as the tenant to fall within the protections of the eviction moratorium under the current law. So that's what exists in the law. There's probably a ton of questions. I know it can get really complicated, and I blew through that very quickly. I'm going to open it up to anyone who has any questions regarding this, or if you have a particular question about what responsibilities or obligations that occur in normal circumstances, I would be glad to answer those. So I'm going to throw it back to Sandy and see if there's anything that's come up in the chat. And if you would, you can raise your questions in the chat. Do we have anything, Sandy?
I'm not seeing anything in the chat, but let's give people a minute here because
I did see something come up. One says, does the hardship declaration pertain to signed lease tenants only, or can their subtenant sign the hardship? It's any occupant. So the subtenant could also sign the hardship declaration. So anybody lawfully residing on the premises. We had another question somebody wanted to read. Type it in there. And
yeah, I'm glad you're looking at your chat because I'm not seeing any in the.
You're not seeing it?
No,
okay.
I don't see them if they come directly to you.
By the way, while we're waiting for any question to come in, I want to thank everybody for attending. We have a good attendance today. I know this is one of the topics that when we're in person, it fills the room, but I'm glad that we're seeing people joining us virtually.
There's a question in the chat. What if
I see it.
Okay, good.
I see it. What if there is a subtenant who does not have a lease and the lease ended with the tenant? That's a holdover situation. The subtenant only takes what the tenant had. So this would be the way I would interpret it, and the judge would have to actually interpret it, is that because the subtenant is staying, in essence, the tenant is still there. If the subtenant came in, the subtenant would have to come in under the notice to the landlord that someone is in there. The tenant, again, tenant and subtenant, the tenant is still on the hook. The tenant, unless a tenant gets a release from the landlord for this new tenant to come in, and that it releases the tenant from his or her obligations under the lease and moves the subtenant up into the tenant category, the tenant is still on the hook. So if the subtenant stays and I'm the landlord, I'm evicting the tenant and the subtenant. Even if the tenant is out of there, contractually, the tenant is still responsible to the landlord. The subtenant is the occupant. So in essence, if the subtenant stays and the tenant has not been released, technically the tenant is still there. And so the rules would still apply to anyone who is lawfully occupying the property. I see there's some notes here.
There, yeah.
A notice was sent to the tenant to end the lease. This would be a landlord sending the notice to the tenant that the lease expires and the lease is ended. But there's a subtenant in there. The rules still apply. All the notices have to be given. Because remember, when I first started speaking about this new law went into effect for both non-payment and holdover evictions. So all the notices would have to be given to the subtenant as well. Even if the lease was ended with the tenant, if the subtenant received, that came in under the authority of the tenant, the landlord still has to go through with the eviction process, even though the lease is not renewed, because then the subtenant does become a holdover. And since the subtenant is a holdover, you got to go through the whole process. What else do we have out there? I know we have a lot of participants here. Do we have anything else?
I'm not seeing anything else at the moment. Anybody else have a burning question for Mike? Here we go.
Does a subtenant, but a subtenant still needs to go through the formal hardship process? Yes, there must be the formal hardship process that the subtenant goes through. So they have to provide their hardship declaration. It has to be a valid hardship declaration, and it has to be one of those hardship reasons, which then could be challenged by the landlord. Anything else? Keep them coming.
Can you evict as a holdover?
Yes, so you can evict people as a holdover, but the hardship declaration will come into play. So the coverage under this is for non-payment evictions as well as holdover evictions. So if the subtenant is having, let's say that the subtenant is having a financial hardship rather than compared to a holdover hardship, then they can file for the ERAP benefits to be able to pay for it. If the tenant is just holding over, tenant or subtenant is just holding over, then the eviction process could go through absent, again, with hardship declarations being served. One of the other conditions have to be met. Maybe they can't meet the hardship declaration, but it could be that they have one of the other reasons of why they can't move. And if they have one of those other circumstances, then again, the landlord can challenge that circumstance and challenge whether or not it's a valid hardship declaration. If it's not, if it's not a valid hardship declaration for financial reasons or for any one of the other reasons, the eviction can proceed through as the normal eviction would proceed through. If they falsify their hardship declaration, that they have the finances, that's what you challenge in court. The court will make a determination that they have been receiving sufficient monies in order to pay the rent. Therefore, their hardship declaration is deemed invalid. And if deemed invalid, then again, the hardship declaration, it gets thrown out and the people proceed through the normal eviction process. And that's what the landlord would prove. The landlord would have to prove that they're on unemployment in this scenario, or has other types of financial assistance that would allow them to pay. Because as we talked about before, there are specific things that the court looks to when deciding whether there is a valid financial hardship, and those are what was the tenant's income before COVID, what's the tenant's income during COVID, what are the other liquid assets that the tenant may have, and then would include other benefits, include unemployment, include Social Security, include anything else. Question came out is, how long does it take for a tenant to get a hardship approved? I'm not sure. I mean, well, to get it approved, the hardship doesn't have to be approved. Remember, we talked about the fact that once they file a hardship declaration, it's valid. It's a rebuttable presumption. It's presumed to be valid. It's then the landlord goes to court to have the court hold a hearing to determine whether or not that's valid or not. And that I can't tell you. I'm not aware yet. Let's face it, this law just went into effect a week ago, or 2 weeks ago. I think that has to be fleshed out with the court, and so you have to go through the procedure, and then the court will have to set it for a hearing. And I don't know what the schedule of the court is going to be. Anything else? Again, this can get really complicated, but we hope that it'll work its way through, and hopefully that there will be enough room in there for courts to make the determination there's legitimate hardship here, they get to stay until January 15th, or there isn't a valid hardship here and the eviction proceeding could continue through. The other thing I put out there is we have discussed that this doesn't absolve the tenant or the mortgagor of their financial obligation to pay the money. So the landlord, in this case we use landlord, it could be the mortgagee as well. The landlord would have the right to sue for a money judgment against the tenant and collect from assets that the tenant has or may have in the future. I know that that's sometimes a difficult challenge to try to collect, but that avenue is still available. That's not stayed. You can still sue to get the money. For non-paying tenants, are there any restrictions on late fees, interest charged for the months of non-payment that would be due at the expiration of the current law? Well, the one provision in there is that hopefully tenants will be able to, or landlords will be able to receive the rent through the ERAP tenant assistance program. And under that particular statute, by accepting the money, the landlord has agreed to waive late fees and interest charges. For those tenants that don't qualify, haven't qualified, isn't going to qualify for ERAP assistance or anything like that, I can't tell off the top of my head what the in the current law, I've read through the current law. There's nothing it says about this is the only provision that says that landlord waives late fees is when they receive the ERAP benefits. It does not say anything about waiving interest for those that aren't getting ERAP benefits. I can't remember if the old law, but the old law is expired, so it wouldn't be in effect. So I don't believe that it would have any effect on late fees and penalties to those people. Anything else? Good questions. Not seeing any questions.
Give it
another minute.
Or so,
yeah, let's give another minute and see.
Comes up.
While we're waiting for that, I can just tell you, I'm holding in my hands, my filthy little hands, the actual law itself. And for those of you that can see my screen, you can see that it's pretty small print, and it is, I believe, close to 40 pages. And it deals with commercial leases, residential leases, foreclosures. So it is pretty detailed. If you ever want to get your hands on it, it's probably out there somewhere that you can look up the, it's under the Senate number. I don't know that it's been given an actual law designation, but under the Senate bill was S 50,001. So S 50001. If you look that up, you can pull it out. And if you're having trouble sleeping at night, I encourage reading this, and you will have it. I've read through the entire thing, so it details everything. If a tenant signs up for an emergency rent assistance and you do not have a lease agreement with them, they are a holdover subtenant. Would you have to engage in a lease with them for more than a year? If you accept the rental assistance money, then you agree as a part of receiving that money that you will not raise their rent for the next 12 months and that you will not remove them for that period of time, except under those exceptions that we talked about before, which is a landlord occupied building of 4 units or less, and the landlord or their immediate family lives or intends to live in there. So we'll see how this plays out when as cases go through. I know that in talking with my colleagues throughout the state, there are starting to be challenges to this new law that just went into effect. So we'll see more of it as the courts flush it out. But this is the latest hot off the presses information for you. And I want to thank all of you for joining us today. I hope it cleared up or explains what the current circumstances are. Hopefully we will get into a more normal time in the not too distant future, including maybe doing in-person sessions at Cornell Cooperative Extension. So without anything further, I'm going to pass it back, and we can hopefully see you next month here on the computer or in person.
Thanks, Mike, and thanks to those who joined us today for this presentation. Mr. Danaher will be back with us on Thursday, October 14th at 11 a.m. with a presentation on consumer rights and responsibilities in the marketplace. You can find the Zoom link on the event listing on our website at ccetompkins.org/events. Thank you all, and have a good rest of the week.